And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I've understood previously that
2 plea deals hit the docket back to back, one fraud case, one credit-related felony, and the state is pushing hard. 10 years, fines, and other cases taken into consideration. But here's the twist. The judge hasn't accepted anything yet, and that tiny legal detail is about to control everything.
Court is calling 2025 CR 008396 and 2025 CR 014167, State versus Melissa Renee Paez. Can I have parties announced for the record?
Trey Maurer for defendant.
All right. And are you Ms. Paez?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. In each cause number, Ms. Paez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 9-6?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, sir.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in 6-7, you're charged with false statement to obtain property or credit, $30,000 to $150,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call him the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, sir.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, the state is waiving the enhancement. And in cause number ending in in the cause number ending in 9-6, the state is proceeding on count 1. And in each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. They're asking that the causes run concurrently. They're taking in consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? In each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
There are not, Your Honor.
And the cause number ending in 6-7 outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact. Did you understand those were recommendations from the state, and the court does not have to follow that recommendation? Then in cause number 2025 CR 008396 to count one, how do you plead?
Guilty.
And in cause number 2025 CR 014167, how do you plead?
Guilty.
State, in each of those cause numbers, do you have any evidence to support the plea?
Yes, Your Honor. State offers States Exhibit 1 and all attachments in both causes.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea of guilty and plea onto these 2 cases. If those 3 cases are closed out, and if the court would additionally consider reducing her bond slightly on the 2 that she has pled on, so she could take those full 8 to 12 weeks, organize her witnesses and people that she would like to be here on her behalf, and make sure that she has everything lined up for whatever the court does decide at that point. I believe that's what we are requesting, Your Honor, if the court would consider dismissing those 3 and possibly just slightly reducing the bonds on the 2 that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving notice, just whenever you all get together, the court will do that. Now, with regards to the dismissals, any objections to the court signing the dismissals now, or?
Object, Your Honor, because that is something that ensures or will be dealt with at the resolution depending on what this court does.
And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I think I've understood previously that if someone enters a plea and then does not return, that that plea can be, the court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll accept whatever the court decides at that point.
All right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals, the signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases, if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being dismissed now, they're really not to be dismissed now, because your plea bargain agreement, I haven't even accepted it yet. and entered a sentence. I've just accepted the contract that you want to enter into. Do you understand? All right.
This is a big courtroom lesson. A plea can be recited on the record, but until the judge accepts it, it's not a done deal. That's why she shuts down the dismiss the other cases now request and asks for case law. What do you think? Smart caution or unnecessary delay?
So, but again, if somebody brings me case law that says something differently, I'll review it. I never said I know everything.
We take a quick step back just so I can discuss with my client very briefly, Your Honor.
Sure. And then let me know if you all want the 12 weeks or not, 8 to
Okay.
12 weeks or not.
Thank you, Judge.
Sure. All right. So are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it going to be the same wait time, Your Honor?
Vashon, how long is TAP just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks, we'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing for prevention.
All right, with that, we'll close the record.
Thank you, Your Honor.
All right, the court is calling 2025 CR 011541 and 2025 CR 011452, State versus Lennon Cortez. Can I have parties announced?
State.
Charles Bunk for Mr. Cortez.
And are you Mr. Cortez? Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Are there any applications?
No, Judge.
In each cause number, Mr. Cortez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We did.
State in each cause number, are you proceeding on the indictment as presented?
The cause ending in 4-2, state moves to proceed on the lesser included offense of possession of a controlled substance, PG2 less than 1 gram.
No objection.
All right, in each cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? In the cause number ending in 4-1, you're charged with unauthorized use of a vehicle. And in cause number ending in 4-2, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering into these pleas, you're giving up those rights? And did you intend to give up those rights and enter into a plea in each cause number? Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah.
Mr. Cortez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
In each cause number, if you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. So on the plea bargain, I'm sorry, I'm having a bit of trouble understanding the time.
It's
On the-
it's 12 months.
41.
Yeah.
Okay, so that's 365. It's just that it was, so it's 365 in each.
Date, yes.
Okay, all right, we're back on the record. And each cause number, according to your plea bargain agreement, punishment is to be assessed at 365 days in the Bear County Jail under 1244. There's an $800 fine. The cause numbers will run concurrently. And then the cause number ending in 42, state is proceeding on the lesser included offense. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney in each cause number? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
No, Judge.
Then in 2025 CR 011542, to the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. How do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 011541, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. Reference to exhibit 1 in all the.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
And they're the same report in both cases, Judge.
Okay, thank you. I'm just looking for the lab report. Ah, it's labeled. I love when it's labeled. All right, in each cause number, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
Odyssey is a little bit slow. And cause number 2025 CR 011541, as previously stated, the court is finding you guilty. Court will sentence you to 365 days in the Bear County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 011542. And is this a judgment satisfied or no?
No, Judge.
Is there anything else with regards to sentencing under that clause number?
No, Judge.
Next, we'll proceed in cause number 2025 CR 011544. I'm sorry, that last cause number, court reporter, was that 542?
The last one was 541.
All right, thank you. Then the next cause number we'll proceed in will be 2025 CR 011542. And in that cause number, as previously stated, the court will find you guilty of the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. Court will follow your agreement, sentence you to 365 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 011541. Is there anything else with regards to sentencing under that cause number?
No, Judge.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. Here's the thing. At the jail, I know sometimes people think they're getting 2 for 1 or 3 for 1. I'm not in charge of 2 for 1 or 3 for 1. So if the jail decides not to give you credit of 2 days for every day you spent, you can't come to me for that because I have no jurisdiction over that. The only thing I can tell you is I've sentenced you to 365 days, and that's my sentence. You understand? All right, good luck to you.
Thank you,
Thank you,
Judge.
counsel.
Final take. Paz pleads guilty in both causes, but the judge pauses acceptance and orders a TAP evaluation, setting the case back for a specific return date, showing that sentencing can hinge on what's learned in that evaluation. In Cortez's cases, the court follows the deal. 365 days in county jail under 12.44, $800 fine, concurrent time, and a blunt reminder. The judge controls the sentence, not 2 for 1 jail credit. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.